Thank you for coming back to Living Equity, guys. We're going to talk about pour over wills today. The importance of pour over wills. Before I continue with anything, let me first say this. I'm not an attorney. I just know some shit. All right, let's get straight to it. We're talking about pour over wills. Pour over wills are very important. You might hear a lot on the internet. Get a trust this, trust that. You know, will, trust. This is far from the truth. Everybody who has a trust, you must have a will. Why do I say that? Because all the items do not ever get conveyed into the trust. Unless you have great administrative skills, you are very on time and you don't waste any time. As soon as you get the asset, it's conveyed into the trust immediately, or you buy it outright inside the actual trust name. These are typically the most ways we can get the items into the trust a lot faster than waiting to purchase the item, my real name, and doing the conveyance and stuff like that happens. Some of us, we don't have the resources, the money, the knowledge, wisdom to make sure this get done in that timely fashion. We have a pour over trust to ensure that the items that we intended to be put in trust gets placed in the trust in the event of our passing. It's like any other trust. We're going to have an executive. We're going to appoint an executive. It could be a friend. It could be family. Anybody that you feel like you can trust in this situation. We're going to make sure they understand your wishes. So remember, even though you have a verbal conversation about your wishes, if it's not written, it didn't happen. Okay. Now, the duty of the executor, or in your state, it may be called a personal representative. Now, one of the first things is they're going to name an heirs. They're going to name your devices, legatees, mainly your heirs if you have any. And then the second, we're going to also list out if a guardian is needed for that minor child. Now, some people say, I have a guardian clause in my trust. That is absolutely fine and perfect. But just in case, it's advantageous for you to have that extra security or level of protection by actually putting in your will as well, so there can be no confusion of what your wishes are. We got the heirs, we got our guardian, just in case you have a minor child. The other thing that the executor or personal representative has to do is what we call inventory. He has to do an inventory. He has to take into account all the assets and property that may still be out there in your name that is actually going to be probated. This goes to probate court. Now, even though it goes to probate court, it does not take the extensive time a probating of a estate does. No, it doesn't cost as much either, because your wish is already lined out to say, I want the executor, upon my passing, do the inventory and convey those items into my trust. That's what you want him to do. Nothing more, nothing less. Now, what we're going to do is, after he does an inventory and account, he's going to convey it to that trust, as I stated. Again, a very quick process in regards to probate court. It still goes to probate. You can't avoid that. If you have anything in your name, if you will, your property will be intestate. It can be tied up in court for months, years, depending on what it is. We always want this will just in case. You really cannot have items being conveyed to the trust when you die. It has to be a will to do so. How can we avoid going to probate? Maybe lessen the job and the stress of our executor or personal representative. Of course, depending on what state you're in, it's called different things. What we can do is we can do for our banks and retirement investments account, we can do a POD and TODs on these accounts. And with your insurance accounts, you typically have a beneficiary, and make sure that stays up to date as much as possible, especially if you have minor children, because what they don't tell you is your children can be beneficiaries to this policy. On the day on your passing, your child is still a minor, it's going to probate court. A child cannot handle that type of money during their age of minority. So it will go to probate court. Be very mindful of how you set up your beneficiaries to your policy, what that looks like for you. Not an attorney, just know some shit. POD, TOD, pay on death, transfer on death, when it comes to your banks and your checkings accounts and your investments accounts, etc. That's what that is for. And I'm going to backtrack a little bit. The duties of the executor, once they do all this here, they're discharged. Their duty is discharged. They have no more duty to the estate. They are fully discharged. How can we lessen the stress and weight on the executor from doing a full account and conveying and doing all those good things? If we, in certain conditions and situations, if you have a power of attorney, and maybe you are in a incapacitated state, maybe you're in your hospital bed, but so many days you have to live, it's knowing that you're going to be exiting the world soon. You will be called home. That power of attorney can come in a good effect and help convey those items to the trust before you pass away. This is estate planning. We try our best to avoid probate court. So we try to set up a little power of attorneys and POD, TODs and things like that so we can avoid going to probate court or lessen the things that our executor has to do an inventory and account for and convey into the trust. It'd be very minimal because a lot of the stuff was done before that event occurred. Now, if you just drop on a dime, of course, that's different. This will not apply because you can't act a power of attorney when that person is no longer living. It only is effective if that person is alive. Now, that's why we have the pour over will in case you do pass away and this does not come into effect. This will ensure all these items gets conveyed into the trust upon the death. And that trustee from this trust will ensure that your wishes are carried out as such. This is a real simple breakdown the importance of a pour over will that a lot of people say you don't need to have. You have a trust, living or revocable, no matter what it is, definitely consider getting yourself a pour over will. Definitely get your executor, make sure they understand the importance of this, your wishes, what's going to be required for them. Also have a successor. You want to have a successor executive or a personal representative just in case the one you appointed happens to pass. Maybe you forgot to update your will. They passed before you and you passed later. You want to have another party in that position just in case that first one you selected cannot fill that position and actually do their duty. Again, this is for educational purpose only. I am not an attorney. I just know some shit. Hopefully this was helpful. Hopefully you learned something today. Pass it around because our duty as while we're on this earth to our children, parents, etc., is to be good stewards. This is part of it. Good stewardship. Again, appreciate you. I guess that's it. See you next time.